مساء الخير جميعا. هلا كل شيء تمام واحنا هلا لايف على اليوتيوب، ففينا نبلش. اهلا وسهلا فيكم جميعا مرة ثانية وبضيوفنا الاعزاء. احنا راح نحكي هيك مقدمة قصيرة بالعربي وبعدها راح ننتقل للإنجليش. أهلا وسهلا فيكم. اللقاء هذا هو اللقاء العاشر من ملتقى القانونية من أجل فلسطين، راح يكون بعنوان آفاق قضية فلسطين في المحكمة الجنائية الدولية ما التالي. هذا اللقاء راح يكون بشكل أساسي باللغة الإنجليزية وبالعربية كذلك. راح يكون في ترجمة فورية من اللغة الإنجليزية للغة العربية. للي محتاج الترجمة موجود اللي على شكل كرة أرضية اللي هو السهم تحت، الإشارة تحت، اكبسوا عليها واختاروا اللغة العربية. We will switch to English now. So hello and welcome everyone to the 10th panel discussion of the Jurists for Palestine Forum, organized by Law for Palestine organization. Today we are discussing a very important and highly debatable question which has arisen in the recent years and mostly during the last year, which is the future of the Palestinian case at the International Criminal Court.
طيب احنا عندنا عطل فني بسيط في الانترنت، ثواني ورح نرجع ان شاء الله. طيب احنا حننتظر دقيقة واحدة فقط إذا إيمان رجعت تنضم. إيمان.
Hello. Yeah, do you hear me?
تمام، صوتك مسموع إيمان، تفضلي. نعتذر عن هذا الخلل.
There was a problem in the internet connection. So thank God. So sorry for this. Going back to our today's session, which will be about the future of the Palestinian cause at the ICC. So as I was saying, the Ben Saud's decision to open investigation in Palestine was a surprising decision, which caused many criticism and many questions also and fears surrounding the future and prospects of this cause before the International Criminal Court. Today we are discussing the future possible scenarios for this case. What are the best scenarios? What are the worst ones? Is there really any chance for Palestine to get real justice from the ICC? What types of cases the court is most likely to go and investigate, whether it will be only war crimes or will it go to crimes against humanity, such as apartheid. And also, most importantly, what can we do from locally Palestinians? How can they facilitate the court's work? And how can we overcome the problem of Israeli announcement that it will not cooperate with the court? Today, we have our guest, Dr. Aisha Al-Basri, and Mr. Pearce Clancy to discuss this issue with our other guests. So we will start with Dr. Aisha Al-Basri. She's a Moroccan writer and journalist, and she's currently working as an international human rights consultant. Dr. Al-Basri is a former diplomat with 13 years of experience with the United Nations, and she was also a former researcher at the Center of Imaginary Studies in Chambéry, France. She was awarded the American Reindhover Award for the Best Truth Detector. Dr. Al-Basri gained her experience in the International Criminal Court through her cooperation with the former prosecutor Ben Souda and other senior staff in the ICC during the case of Darfur. Dr. Aisha has also several publications on the issue of international court and Palestine, and her recent one was in 2021 on the possible scenarios for Palestine at the ICC. Dr. Aisha, the floor is yours for the next 15 minutes. I think Dr. Aisha will speak in Arabic. So for English interpretation, you can click on the globe icon just down the screen. Dr. Aisha, the floor is yours. Thank you.
شكرا دكتورة إيمان، شكرا لمنظمة القانون من أجل فلسطين وللمشاركين والحضور لهذا اللقاء. يشرفني طبعا أن أناقش هذا الموضوع، موضوع الساعة طبعا بالنسبة لفلسطين. وأريد في البداية أن أشير فقط إلى أن يعني فتح التحقيق، قرار فتح التحقيق من طرف المحكمة الجنائية الدولية هو في حد ذاته هو مكسب بالنسبة لكل من جاهد في سبيل فتح هذا التحقيق، كل القانونيين والمناصرين عبر العالم للقضية الفلسطينية. لماذا؟ لأن هذا التحقيق، قرار الدائرة التمهيدية، أولاً وضع التحقيق في الجرائم وضعه في سياقه الصحيح، اللي هو موضوع الاحتلال، سياق الاحتلال الإسرائيلي، ثم حدد نطاق هذا الاحتلال، أي الأراضي التي احتلتها إسرائيل منذ 1967، لا سيما قطاع غزة والضفة الغربية بما في ذلك القدس الشرقية. ثم جرم أنشطة الاستيطان التي يشرعها أو يحاول شرعنتها النظام الإسرائيلي عبر ممارساته وسياساته. ويكون بهذا القرار قد ضرب سردية الأراضي المتنازع عليها. كما تعلمون إسرائيل لا تؤمن بأنها دولة محتلة، بل هي تتكلم عن أراضي متنازع عليها، وهناك تفاهمات وترتيبات لتجاوز هذا الموضوع. فالقرار نفسه، قرار فتح التحقيق، ضرب هذه السردية، وهذا انتصار كبير بالنسبة للقانونيين وبالنسبة للفلسطينيين على العموم. الآن السؤال المطروح، أين نحن من هذا التحقيق؟ الموضوع الذي سنتناوله اليوم على الأقل من جانبي ليس هو سيناريوهات التحقيق، بل هل التحقيق سيمضي قدما وكيف سيمضي قدما؟ هذا هو الموضوع المطروح الآن. حاليا تجاوز التحقيق أو القضية المطروحة على المحكمة تجاوزت الفصل المادة 53 من نظام روما الأساس، أي أنه تم حسم الأمر في 4 معايير التي هي مقبولية، يعني هناك أساس معقول لإجراء تحقيق، مقبولية القضية، خطورة الجرائم، وخدمة مصالح العدالة. كل هذه الأمور تم حسمها وفتح التحقيق. فلا أظن أنه سيتم التراجع عن التحقيق كما يطرح يعني من بعض سيناريوهات. لا أظن أن المدعي العام سيتراجع عن التحقيق وسيغلق نظرا لضرب إحدى هذه النقاط. الآن كما يوضح كتاب سياسات المحكمة، يوجد التحقيق على مستوى المادة 54 من النظام الأساسي، والتي تتعلق بواجبات المدعي العام وسلطاته. وهنا الآن يعني ما يجري الآن هو تحقيق في ظروف التجريم والتبرئة وجمع الأدلة والتماس التعاون، بالإضافة إلى طلب حضور يعني من بعد طلب حضور المشتبه بهم للاستجواب. هذه هي الآن أين تدور حلقة التحقيق حاليا، هذا هو الموضوع. هناك طبعا ضوابط لهذه العملية، وهذه الضوابط حددتها سياسات المحكمة نفسها. هناك بوليسي بيبر لبنسودة أظن أنه نشر منذ 2015 أو 16، وهو يعني ساري مفعول. وهناك أيضا توصيات تقرير لجنة الخبراء لاستعراض عمل المحكمة واستعراض أيضا جمعية الأطراف للمحكمة، المعروف بتقرير جولدستون ل 2020 تم نشره في سبتمبر من السنة الماضية، وهو جد مهم، يعني يحتوي على 384 توصية، لكن ما يهمنا هي توصيات بشأن التحقيق. هنا في هذا التقرير يقول الخبراء، وهذا التحقيق أهميته أنه تم تبنيه واعتماده من طرف جمعية الأطراف، دول الأطراف التي تكون المصادقة على نظام روما أو الموقع عليه، تبنته ووضعت له آلية لرصد تطبيقه، فهو يعني معتمد. وقد التزم كريم خان المدعي العام بالسير يعني في إطاره. هذه التوصية تقول بأنه في إطار التحقيق، حين يبدأ التحقيق في القضايا المطروحة على المحكمة، هناك 3 حالات. أولاً الحالة الأولى تتعلق بوضع أو منح أولوية لتحقيق ما لقضايا ما، وهذا يعني أنها سترصد لها موارد هامة وستكون prioritized. ثم الحالة الثانية هو تخفيض الأولوية لهذه القضايا. هذا يعني أنها ستكون القضية ستكون نشطة، يعني سيتم التحقيق فيها لكن بموارد أقل، وهذا يسمى deprioritization، يعني هذه الحالة الثانية. ثم الحالة الثالثة وهي تجميد تحقيق ما، الهايبرنيشن، يعني أن التحقيق لا يتم طبعا التخلي عنه، وإنما يتم حفظ المعلومات ويتم يعني استمرار في التحقيق لكن بصورة أقل جدا، يعني شبه مجمدة، الهايبرنيشن. ففريق الخبراء أضاف يعني توصية أخرى بأنه يمكن يعني إغلاق التحقيق إذا ما تبين أن هناك يعني عامل مثلا توفي الشخص المشتبه به أو أشياء من هذا القبيل، يعني major cases. فالمهم هناك 3 حالات. ما يحدد هذه الحالات يعني حالات التحقيق الأولوية المخفضة والتجميد هو ما يسمى ب feasibility factors، عوامل الجدوى، التي هي كمان من التوصيات التحقيق جولدستون، والتي تتحدث عن قدرة مكتب المدعي العام في القيام بتحقيق ناجح يؤدي إلى مقاضاة المشتبه بهم ويضمن إلى حد معقول يضمن إدانتهم. يعني بعبارة أبسط يريدون السكسس فاكتور، يعني يقولون أن الأولوية ما يحددها هو قدرتها على النجاح. لا يريدون يعني تكرار تجربة بنسودة وما قبلها، يعني الذهاب في تحقيقات ثم في الأخير لا يتوصلون إلى إدانة أو لا يتوصلون حتى إلى بداية المقاضاة. يريدون يعني حالات أدلة قوية، ظروف أمنية لإجراء التحقيق لابد أن تكون هناك، التماس التعاون من طرف الدولة المعنية. كل هذه يعني الأولويات، المعايير هي التي تحدد إن كانت قضية ما ستعطى لها الأولوية أولوية مخفضة أو ستجمد. هنا نصل لنقطة جد هامة وهي نقطة التعاون. الحجر الأساس بالنسبة لهذه المحكمة هي محكمة لا تفرض نفسها، ليست لديها آليات لتنفيذ قراراتها، فهي تتوقف بشكل كامل على تعاون الدول. إذا لم تتعاون الدول ليس بإمكانها فرض قراراتها، وليس بإمكانها ولوج مسارح الجرائم وجمع الأدلة ويعني إجبار المشتبه بهم بالحضور إلى آخره. طبعا على مستوى قانوني لديها إمكانية، لكن على مستوى الواقع ليست لديها ضمانات لتطبيق هذه القواعد. فالمشكل الأساس يعني أكبر معيق للتحقيق هو تعاون الدولة الإسرائيلية التي كما تعلمون ترفض وجود المحكمة واختصاصها، وترفض طبعا الاعتراف لا تعترف بفلسطين كدولة ولا تعترف باختصاصات المحكمة. وللأسف هذا هو الوضع الذي يجعلني لا أريد أن أخوض في سيناريوهات كثيرة، لأن هذا السيناريوهات تدور حول التعاون. ولحد الآن الحكومة الجديدة المتشددة الصهيونية المتطرفة بقيادة بنت ترفض تماما الاعتراف بالمحكمة وتعاونها، يعني نفس السيناريو تواصل للأسف. ولذلك نحن نقول يعني بهذا الصدد ليس هناك ما يلزمها، يعني من ناحية قانونية ليس هناك ما يلزم. ممكن الضغط طبعا على إسرائيل، لكن المدعي العام سيكون مجبر في يعني البقاء في مرحلة التحقيق. نظرا لعدم التعاون سيكون جد صعب بالنسبة له ولوج مسارح الجرائم، جمع الأدلة، التقاء بالشهود. ممكن طبعا أن يحاول كما أشرت في دراستي أن يحاول التحقيق عن بعد الذي اعتمدته بنسودا وأوكامبو، لكنه لا يميل لهذا النوع من التحقيق. هو يفضل التحقيق على الأرض ويريد قضايا جد قوية، ويصر جدا على تعاون الدولة المعنية بالتحقيق. وهنا طبعا هناك دولتين. فنظرا لهذه العوامل أظن أن التحقيق هذا هو السيناريو الذي تكلم، هو ما يسمى بصيرورة التحقيق. يعني قضية فلسطينية، الجرائم التي سنتحدث عنها ويعرفها الجميع ستدور في عملية the process of investigating، هو الذي سيأخذ وقت. في البداية طبعا سيشرع قد شرع طبعا المدعي العام في التحقيق. الآن هم بصدد جمع الأدلة حسب هذه الأدلة والتماس التعاون من الدولة. سيأتيهم الرد من طرف إسرائيل، التماس طلب التعاون، سيكون بالرد إن ردوا طبعا من الاحتمال أن لا يردوا. وهنا سيكون المدعي العام مجبر بأن يعلن عن وضع الكيسز، يعني وضع القضايا، وسيكون مجبر لتحديد الأولوية التي سيمنحها لهذه القضية. يعني يا إما يعطيها الأولوية في البداية، ربما قد يمنحها أولوية وموارد من أجل جمع الأدلة، ثم في فترة لاحقة إن لم يتغير الوضع وإن واصلت إسرائيل في رفضها التعاون ويعني رفض ولوج الأراضي مسارح الجرائم، هنا سيكون مضطرا لتخفيض أولوية التحقيق وربما لاحقا تجميدها. طبعا هذا نحن لا نتمناه، لكن حسب ضوابط التحقيق التي تحددها المحكمة، يعني سياسات المحكمة المنشورة، وحددها أيضا تقرير خبراء أغسطس 2020. هذا هو السيناريو الذي تتحرك فيه القضية. هنا أقول أنه ممكن من الإمكان طبعا الاستفادة من عملية تحقيق هذه، حتى ولو أن هذا الإطار يعني ليس بإطار إيجابي يعني 100% وحتى ب50%، لكن ممكن الاستفادة منه. كيف؟ عبر الضغط على المدعي العام لفتح تحقيق في جرائم الاستيطان وجرائم متعلقة بالأبارتايد. الجرائم الأمنية هي ليست من مصلحة الجانب الفلسطيني. لماذا؟ لأن هناك طبعا تحقيقات على الأرض ستكون جد صعبة، ثم من الناحية الإسرائيلية سيتحججون بوجود قضاء قادر على محاكمة الإسرائيليين من جانبهم. وهنا قد نسقط في السيناريو الأسوأ الذي هو محاكمة حماس، عناصر من حماس وفصائل أخرى. هذه العمليات الأمنية بالنسبة للمحكمة هي طبعاً أفضل، لأنها تبعدها عن القضايا السياسية الأكثر تأسيس اللي هي الاستيطان والأبارتايد. لكن للاستفادة من عملية التحقيق أو الشروع في التحقيق the beginning of the process of investigating، أظن أنه لا بد من الضغط على المدعي العام لفتح تحقيقات في الأبارتايد، لأنه هنا يمكن الربط بين المشروع العدالة الذي نتحدث عنه في إطار المحكمة الجنائية، وأيضا القضية الشكوى المطروحة الآن على طاولة لجنة القضاء على جميع أشكال التمييز في الأمم المتحدة، والتي للأسف لم يسلط عليها الضوء حاليا، ولكنها جد مهمة لأنها الآن يعني تم الإقرار بأن إسرائيل تمارس ميزان عنصري بجميع أشكاله، والآن ممكن أن يتم الضغط عليها لرفع التحفظ حول تقديم القضية لمحكمة العدل الدولي. بالإضافة إلى لاحظنا جميعاً أن هناك يعني ازدياد بوعي مظلومية الفلسطينيين، والمناصرة الدولية التي شهدناها مؤخراً في قضية شيخ جراح. الأهم بالنسبة لي في عملية التحقيق الآن يعني هي محاولة توصيف إسرائيل كدولة أبارتايد. إذا استطاع يعني المسؤولون عن القضية في المحكمة الجنائية الدفع بالتحقيق في هذا الميدان، سيتم ترسيخ هذا التوصيف. The labeling هو أهم حاجة، أهم شيء بالنسبة للقضية الآن، وهو الذي يعني أبلغ جنوب أفريقيا لمستوى أنها صارت يعني توصف بدولة منبوذة، وهذا أكبر خوف بالنسبة لإسرائيل، ليس خوفاً من العدالة وخوفاً من الرأي العام الإسرائيلي. وهذا هو بالنسبة لي أهم خطر على إسرائيل، هو تحول في الرأي العام الإسرائيلي لصالح القضية الفلسطينية، لأنه كما تعلمون لم تهزم أمريكا يعني في فيتنام أو فرنسا في الجزائر، ما هزمها هو انقلاب الرأي العام في الولايات المتحدة وفي فرنسا ضد هاتين القوتين، وممكن توقع نفس الشيء بالنسبة للقضية الفلسطينية. سأتوقف عند هذا الحد، وطبعا أرحب بالنقاش لاحقا. شكرا.
Thank you very much, Dr. Aisha, for this very insightful and important points that you have mentioned in this question. So, Dr. Aisha, to just summarize what Dr. Aisha was saying is that there is sorry, like in the recent report of the experts, Goston report, regarding the reparations in the court's action, put the Palestinian cause a little bit into risky scenarios. With the current prosecutors, Karim Khan adoption of this report, which was not the same case during the former prosecutors. So we have, there is a three during the investigation, which is whether to give it prioritization to the case, whether make it less prioritized, but still going out, whether to froze it at all till the future, till there will be feasible and feasible actors or factors to go on with a successful investigation. So what Mr. Khan wants is success cases that will actually and on the ground will bring criminals before the court. And the other important issue, which Dr. Aisha was mentioning, is the cooperation of Israel, which is the biggest fear actually that's facing the Palestinian cause, is that the complete refusal of Israel to cooperate. And with Karim Khan's prospect of investigation to go to investigate on the ground, it might be difficult for him to see the case as the feasible case or a success case, since he cannot reach the occupied Palestinian territories, which all borders are controlled by Israel, despite that it's Palestinian land according to the pre-Shamble decision. So what Dr. Aisha was finally saying is that actually the successful thing or the most important thing is to benefit from the process of investigation, even though if nobody will be actually brought before the court. And this will benefit in the public opinion, international opinion, and the framing Israel as a criminal state in many cases, especially in such clear cases of crimes such as the case of apartheid and colonialism. But what Dr. Aisha is saying is that most likely there is not really very optimistic scenario of bringing Israeli criminals before the court. Moving to our other guest, Mr. Pearce Clancy, who is a PhD candidate in international law at the Irish Centre for Human Rights in the National University of Ireland. He served as a legal researcher with Al-Haq organization in the Department of International Criminal Law and International Criminal Court. He has previously contributed to submissions to the court regarding the situation of State of Palestine. And he is an author and co-author of several publications regarding ICC and Palestine. So continuing Dr. Aisha's talk on the scenarios, possible scenarios for Palestine in the ICC. What do you think, Mr. Pearce? What are the obstacles or the other obstacles that might face the case to move on in the court? And do you have a more optimistic view of what might happen or where the case will go? The floor is yours for the next 15 minutes, Mr. Pearce.
Thank you, Iman, and thank you everyone at Law for Palestine for inviting me to take part in what I think is a very important discussion on an issue that is at once incredibly complicated, but also quite important. The short answer to your question is that I am optimistic, but I disagree with very little of what Dr. Al-Basri has said. And thank you to Dr. Al-Basri for a very interesting intervention. So what I want to try to do in these 15 minutes is explain that statement, in the sense that I want to talk a little bit about limitations that are faced by the court and the limitations specific in the situation in Palestine, repeating perhaps some of what, or echoing some of what Dr. Al-Basri has said, but then also try to bring in some of the optimism that you alluded to, and how value can, I think, be brought to the Palestinian cause by the situation in the state of Palestine before the ICC. So in terms of scene setting, and in terms of sort of an introduction, at the outset, I think it's important looking at the Rome Statute. Also, I should say, I hope everyone is okay with me speaking in English. As you can probably tell, I'm not Palestinian, I'm actually Irish, which means, first of all, that I am speaking Arabic, but second of all, means that our interpreters are probably in for a very difficult job. I'd like to thank them and apologize in advance. But at the outset, looking at the Rome Statute, I think
if you can talk a little bit slowly so the interpreters can catch up and interpret. Thank you.
Of course, that's another aspect of me being Irish. I have a tendency to talk very fast. But as I was saying, looking at the Rome Statute, there's a number of limitations before we even get to the situation in Palestine that are inherent in the Rome Statute. In particular, jurisdictional limitations on what the court may and may not look at. In the context of the situation in Palestine, there's two limitations here with regards to jurisdiction. The first is temporal jurisdiction, in the sense of what time span the court may look at, what conduct it is permitted to look at. It is only permitted in the context of the situation in Palestine to look at alleged or suspected crimes that have been committed since the 13th of June 2014. That is the point at which the temporal jurisdiction of the court in this situation begins. Any alleged criminality, no matter how grievous, no matter how disturbing or whatever it might be, may have taken place before June of 2014, is in effect off the table. Even if the prosecutor wanted to, he cannot investigate those crimes. The exception to this is to so-called ongoing crimes, crimes that perhaps began before the 13th of June 2014, but are still ongoing. So for example, settlements in the West Bank and East Jerusalem that were constructed before 2014, but still exist, continue to be maintained. The population transfer at the core, sort of at the legal root of those settlements continues to have a presence, continues to exist. It can be looked at. There's still quite a significant limitation in a situation that is characterized by suspected international crimes going back 73 years, right? The second territorial or jurisdictional limitation that I see does actually have to do with territorial jurisdiction. The issue that Fatou Bensouda put to the pretrial chamber at the end of 2019, beginning of 2020. And even that the pretrial chamber affirmed in February of this year that the court has territorial jurisdiction in the West Bank, including East Jerusalem and the Gaza Strip. That in itself is quite limiting, in that that means, at least prima facie, that the court has no jurisdiction to look at the treatment of Palestinian citizens of Israel or Palestinians living in 48 or in Israel proper. That is in effect off the table because the jurisdiction is set at what the court recognizes as a territory of the state of Palestine. That's not even addressing the question of where Palestinian refugees who are denied their right of return and are living as exiles abroad fit in. There is a strong case that has been made by writers like Michael Kearney and John Quigley to say that right of return could be prosecuted by the ICC as a crime against humanity. This was done, or it was alluded to, it was sort of suggested by a pretrial chamber of the court in the context of the situation in Bangladesh and Myanmar, although it's unclear as to whether or not the prosecutor would even put forward such an argument in that case, but it's worth keeping in mind. So those are the jurisdictional limitations, first of all, but it's also important, I think, to recall the political limitations, the very obvious political limitations that would inevitably be faced by the court. Now, putting aside what I'm sure is an immense amount of pressure that is being put on Mr. Karim Khan as the new prosecutor, and putting aside the fact that at least publicly, we do not know exactly where he stands with regards to the situation in Palestine. The specifics, I think, of the situation in Palestine do a good job of illustrating the malleability, right, of the Rome Statute state cooperation regime. And this is something that Dr. Al-Basri talked about a minute ago. The state of Israel, as we all know, is not party to the Rome Statute. And so, strictly speaking, there isn't a legal obligation to cooperate. It cannot be compelled, no matter what court you bring it to to cooperate with the ICC, at least not within the terms of the Rome Statute. That means that there's no legally enforceable requirement for Israeli authorities to provide access to the ICC personnel and investigators, something that has been faced by successive UN special rapporteurs on the situation, the human rights situation in the Palestinian territories occupied since 1967, and by successive UN commissions of inquiry, which were denied access. And it certainly means that there's no obligation on the Israeli authorities to execute arrest warrants, to conduct arrests and make surrenders of Israeli personnel to the court. It's unfortunately not within the power of the court to compel that when Israel is not a state party. I think it's similarly unrealistic to expect the Palestinian Authority to carry out that function due to a lack of de facto power, to a lack of access to important parts of the OPT, which will be key in the investigation. I'm thinking in particular about East Jerusalem and Area C of the West Bank, where the PA presence is effectively, if not genuinely, non-existent. It's also important to recall the PA's lack of criminal enforcement jurisdiction over Israeli nationals under the Oslo Accords. Now, there's credible and I think very compelling arguments to be made, and I would make them, that the Oslo Accords are to a certain extent inapplicable, lapsed, legally void in 2021. However, by reading the pretrial chamber's decision from February of this year, it seems quite clear, particularly in the context of Judge Kovacs, that they would disagree with me and that the Oslo Accords will continue to be an important part of this litigation going forward, and so they must be kept in mind. That's putting aside, and it's almost sounds silly to say, the more realistic or the logistical question of even if the PA took suspects into custody, how they would get them out of, let's say, the West Bank, when Israel controls all the external borders of Palestine, of mandatory historic Palestine. I don't want to dwell too much on it, but I would also recall that in the context of the Goldstone Commission, access was gained to Gaza because Egypt allowed them in. You don't necessarily need to go through Israel to get to Gaza. You don't need to go through 48. However, Egypt also is not a state party to the Rome Statute for its own political reasons, and so it cannot be compelled to cooperate. And cooperate was something it did not do in the context of the 2018 Commission of Inquiry into the Great Return March and the repression of that, of those protests. Finally, in terms of limitations, there's a broader point to be made and a broader limitation in terms of international criminal law itself and the fabric of, let's say, our modern understanding of the international criminal justice system. That is to say that this is a branch of international law which is concerned primarily with individuals and individual responsibility, and is ill-equipped, if not totally unequipped, to deal to address broader structures of violence, structures of settler colonialism, and structures of apartheid, such as those that you see in Palestine. This is to say, you can prosecute someone for willful killing in the West Bank if you can get access to them. You can prosecute someone for the forced displacement of a family in East Jerusalem, or the disproportionate and wanton bombardment and destruction in the Gaza Strip. But we must also recall that putting individuals behind bars or in the dock at The Hague is not the same as dismantling and removing the ideological and structural root causes of why those crimes were committed in the first place. It's important to remember that the ICC was never designed to end a 54-year occupation, to dismantle an apartheid regime, or to reverse the damage done by 73 years of settler colonial domination. So quite a bit has to happen to bring perpetrators to trial in The Hague. First of all, the Office of the Prosecutor has to have the continued political will to do so, which might be a big ask, which might be a big if, given that we don't know where Mr. Khan stands. They must manage to conduct an investigation almost certainly without access to the crime scene and to direct evidence. And they must gain access to suspects. You can't try someone in absentia at the ICC. That'll likely have to be done through the territory of third states, such as European states, whose sympathies perhaps more largely lie with Israel than with the Palestinian victims calling for their help. None of these steps will be easy. So given the past 10 minutes, it's probably easy to imagine that I'm quite cynical about what the ICC can do and benefits of the ICC, but that, again, is not true at all. I think the tremendous value that the ICC can have in Palestine. And even though I like it seems Dr. Al-Basri, don't personally believe that we'll see Israeli personnel in the dock anytime soon. I think that viewing prosecutions and the prosecution of Israeli personnel as the only way in which value can be gained from this investigation is unduly short-sighted. I'm concerned that there's a tendency amongst international criminal lawyers, in particular, if you understand international criminal lawyers, who are engaged with or observing the situation in Palestine, to see the ICC as, if you understand, the panacea, as a silver bullet, something that can single-handedly fix everything that's wrong in Palestine. It simply can't. What it can do, and what I think it's already begun to do, is to bolster wider accountability, advocacy, and activist efforts. These efforts, which of course include the opening of the investigation over the past couple of months, have gone a long way, have gone a tremendous way in legitimizing and vindicating the Palestinian cause. And if we think back to January 2021, to the start of this year, it was unthinkable that Israeli apartheid would be discussed in the US Congress. If someone had said that to me, that was going to happen this year, I would have told them that they were out of their mind. It was never going to happen. It was almost impossible to imagine the scale and the sort of power of the protests that took place in May on both sides of the Green Line in 48 and 67 and across the world by those acting in solidarity. And it was absolutely unthinkable, at least in civil society circles, I think, to expect the United Nations to establish a commission of inquiry that would look at the Palestinian people as a whole, not just specific issues like settlements or just the Palestinian people who live in the Gaza Strip and the West Bank, but also to recognize, to see and to recognize the harm being done to Palestinians living in 48. All of these events and all of these breakthroughs are mutually reinforcing. They strengthen each other, right? In isolation, in my opinion, I don't think any of them have the potential to upend the realities of the past 73 years. I don't think they're powerful enough. But maybe they can in unison, right? What the ICC can offer to that mix that's unique and can't be done anywhere else is to pronounce on key Israeli policies and practices as, at the very least, ostensibly criminal in nature. It's something that we as an international legal community haven't been able to do before. It's just not been in the mandate of any former international or UN mechanism. And that doesn't necessarily have to be done through prosecutions. Before anyone is brought to trial, before anyone is prosecuted at the ICC, the court has to issue an arrest warrant. If the Office of the Prosecutor and a pre-trial chamber manage to issue one of those arrest warrants, or if they're interested in doing so, that alone, I think, would be a significant win in what Professor Richard Falk refers to as the legitimacy war, right? And the impact of that would be felt far beyond Hague and would be felt long, long before the guilt of any specific defendant, whoever they might be, is established, should the situation even progress to that advanced sort of end game stage. So together with grassroots efforts, the increased visibility of Israeli practices and policies, thanks to social media and places like Sheikh Jarrah, such as what Dr. Al-Basri mentioned, the mainstreaming of the language of apartheid, which has been rocketed forward in recent months, thanks to, of course, the work of incredible Palestinian activists, advocates, and organizations over the past 20, 30, 40 years, and other such developments, including the new Commission of Inquiry, including the interstate complaint underway at the Committee for the Elimination of Racial Discrimination. The ICC has a crucial role to play in pressuring the international community to take meaningful and effective steps to address injustice in Palestine. This is all to say that inaction on the part of the international community would become increasingly difficult, or if we're to be very optimistic, hopefully impossible, in a situation where the world's highest criminal court has identified Israeli state policies as criminal in nature, and including the willful killing and targeting of civilians, widespread and systematic population transfer, and of course, apartheid. And that can be done, I think, in a symbolic sense, without needing to worry about how we get anyone to The Hague. So that is why I'm optimistic. I think over the past year in particular, we've seen the space for an institution such as the ICC to do tremendous work. And I'm looking forward to discussing this more over the time we have left.
Thank you so much, Mr. Pearce, for this important point on the limitations that might face the International Criminal Court during its investigation, including logistical, political, the Oslo Accord, and the cooperation issue from the Israeli side. But where I can see you meet with Dr. Aisha Al-Basri is the importance of labeling or framing Israel as a criminal state and that has a criminal practices, which will actually drive the international community for take more action toward Israel. So we are a little bit after the time, so we have about, let's say, 35 minutes maximum, maybe 40 minutes if we can get some 5 extra minutes to discussion. So we will open now our panel discussion with our distinguished guests today. We have among the guests a member of the Board of Trustees at Law for Palestine, Mr. Iman Zueiter, and we have also the Doctor of International Law at the Islamic University of Gaza, Dr. Ahmed Shihab, and other venerable guests with us who are researchers and specialists in the issue of international law and Palestine. So we will open maybe a round of 3 questions or interventions or opinions, so it's not only questions. And then we will turn back to our guests to answer or comment, and then we might take another round of 3 questions. Is that okay? So let's go. So who has, the floor is just for raising hands for questions. You can raise hands or just write in the chat. You can also write your question in the chat if you want, and you can do it in Arabic or English. Yeah. So do we have any questions or opinions or interventions? Yeah. So the interpretation is going well, right? Okay. Any interventions or questions? So until we have questions, what I wanted maybe to start with the first question of actually you have, Dr. Aisha mentioned the case of that the scenario might reverse against the Palestinians, and that might Palestinian let's say fighters or officials get brought to the court. Can you elaborate more on how can we avoid as Palestinians this issue? What can be done to avoid this scenario from happening? Yes.
Dr. Al-Basri, would you like to?
Okay, sorry, I got it. Okay. I think I will respond in English just to keep the debate flowing probably a little better. I think the worst scenario is to see the case actually backfire on the Palestinian side if the investigation goes ahead and if it reaches the actual phase of prosecution and which would bring Hamas, members of Hamas and other groups. That would be the worst, of course, scenario, because in such case, instead of investigating Israeli criminals, the Palestinians would be on the worst side. And this is, of course, a scenario that would only happen if Israel would accept to cooperate. And if the situation on the ground improves, and if the ICC has access to an opportunity to turn the information that it has into evidence, which is the main condition for going ahead with the investigation. So if those elements are available and the investigation goes ahead, and the Israel cooperates in terms of bringing members of Hamas to prosecution, that would be the worst case scenario. Of course, many members of Hamas and others have repeatedly declared that they have no problem with that, since they are on the right side of justice. Their resistance is, of course, illegal, except there are many issues with the resistance. When you target a civilian area, you're no longer protected by the law. So there are, of course, risks that if such scenario takes place, Hamas would be in a very deep problem. How to avoid it? There is, of course, the possibility of challenging the ICC and taking back the right to prosecute Palestinians. As you know, the pillar of the court is the complementarity principle. The court
sorry for interrupting you, Dr. Aisha. We just have an issue with the interpretation, and I think that two interpreters are interpreting simultaneously. So if one of you, Malik or Noor, can give the floor to the other. Thank you. Sorry, Dr. Aisha, you can.
Okay. So what I was saying is that the main pillar for the court is the complementarity principle. The court can only prosecute and investigate when a country is not willing or not capable of doing so. So if the Palestinians, both in Gaza and the West Bank, are willing to take on this responsibility, which means that they would have to build the institutions, they would have to laws, they have to adapt to the jurisdiction of the court, then they can take on the prosecution of members of Hamas and others, in case, of course, they are brought forward for prosecution. So this is the worst scenario, of course. And the Karim Khan has repeatedly insisted on encouraging member states, states of the course, of course, to take on the responsibility of doing justice, of prosecuting and investigating their cases themselves, because the court cannot provide for justice for all states. So it would be, of course, it would be difficult, because to convince the court to take back the prosecution of Palestinians, but there's many indicators in terms of Khan's policy and views that he would be willing to help such case to happen.
Thank you, Dr. Aisha. I think Bashar has a question. So Bashar, go ahead.
شكرا جزيلا أستاذة إيمان، ومساء الخير للجميع. كنت بصراحة حابة أحكي كمداخلة بخصوص إنه كتبنا الموضوع، كان لنا مقال انتشر مؤخرا عبر المنظمة، ولكن الدكتورة عائشة تطرقت إلى موضوع المقال فيما يتعلق بموضوع التعاون، وبالتالي لا داعي للحديث فيه. ولكن من المهم أنه نركز على السيناريوهات المطروحة والمآلات تبعت التحقيق اللي ماشي في المحكمة، خاصة في ظل رفض إسرائيل التعاون مع المحكمة. السيناريو اللي كان غائب هو سيناريو تدخل مجلس الأمن لإرجاء التحقيق استخداما بسلطته حسب المادة 16 من نظام روما، هذا السيناريو كان قبل شهرين كان فرصه بتزيد انه مجلس الامن ما يتم استخدامه، خاصه انه عبر تاريخ المحكمه منذ تشكيلها لم يتدخل مجلس الامن لاستخدام هذه الصلاحيه ولم يرجع اي تحقيق. اما الان قد تزداد فرصه الى استخدام هذه السلطه في التحقيق، في ارجاع التحقيق في الحاله في فلسطين، لانه من المهم انه نفهم المسار اللي توجهت فيه فلسطين للمحكمه الجنائيه الدوليه. مسار فلسطين امام المحكمه الجنائيه الدوليه كان بال 2009 كان نتيجه فشل المسار تبع التسويه، مسار اوسلو اللي كانت ماشيه فيه منظمه التحرير والجانب الاسرائيلي، وفي ظل تعثر هذه المفاوضات توجهت السلطه الفلسطينيه ومنظمه التحرير الى مسار تدويل القضيه الفلسطينيه وطرقت ابواب المحكمه الجنائيه الدوليه، وهي كانت المحاوله الاولى وفشلت. وبالتالي الان نسمع انه بعد احداث هبه الاقصى والقدس في الاحداث الاخيره نسمع بان الاداره الامريكيه ودول كثير في العالم وفي الاقليم تدعم عوده الاطراف اي الفلسطينيين والاسرائيليين الى مسار السلام ومسار التسويه السياسيه. وبالتالي قد يتدخل مجلس الامن هنا ليعطي فرصه لاحياء عمليه السلام، وخاصه انه بنسمع انه في مبعوث الى منطقه الشرق الاوسط تحديدا بالايام الجايه، واعتقد وصل هادي عمر وصل الى الاراضي الفلسطينيه واسرائيل بمحاوله لتحسين الثقه بين الطرفين. وبالتالي متوقع جدا ان يستخدم مجلس الامن باعتقادي كبشار انه يستخدم هذه الصلاحيه. ما بعرف الى اي مدى قد تتفقوا مع هذا المسار، ولكن من المهم ادراكه، مع ان فرص كريم خان بان يمضي قدما في التحقيق ما زالت موجوده، وبالعكس تزداد، على اعتبار بان المحكمه تملك من الصلاحيات ومن الديناميكيات القانونيه خاصه عبر تعاون الدول، وخاصه كمان ايضا عبر دخول المحكمه الجنائيه وطاقم المحكمه الى الاراضي الفلسطينيه عبر البوابه الجنوبيه للاراضي الفلسطينيه اي معبر رفح ووصولا الى قطاع غزه. ولكن ايضا هنا بتصير عندنا اشكاليه، يجب كمان انه نفهم ان المحكمه تباشر التحقيق في 3 قضايا رئيسيه: قضيه الاستيطان، وقضيه الحرب غزه 2014، وقضيه مسيرات العوده لاي الاعتداء على المتظاهرين السلميين عام 2018 على الحدود مع غزه. القضيتين الاخيرتين اللتان ذكرتهما هما يتعلق بالاقليم، اي مسرح الجريمه هنا غزه، وبالتالي من السهوله بمكان على طاقم المحكمه ان يدخل الى الاراضي الفلسطينيه عبر مصر وان يجري التحقيق وان يقابل الضحايا والشهود على ارض الميدان. ولكن الاشكال هنا يبقى في جريمه الاستيطان، وبالتالي التحدي الاكبر هو سيتعلق بالضفه الغربيه. كيف سيحقق كريم خان بجريمه الاستيطان؟ والاستيطان عمليا هو في حدود الضفه الغربيه وفي القدس الشرقيه، اللي هو داخل حدود الاختصاص الاقليمي التي تباشر عليه المحكمه. وانا بعتقد بانه المنظومه الاسرائيليه بشكل كامل قد تساعد المدعي العام كريم خان على اجراء التحقيق، خاصه بانه اسرائيل تمارس جريمه الاستيطان في اطار ممنهج. تشريعات الكنيست الاسرائيلي اي القوانين الاسرائيليه ومنها قانون القوميه الاسرائيلي الاخير يدعم الاستيطان، ويقول بالعكس ان من واجب الدوله ان تدعم الاستيطان. ولكن باعتقادي ان من المهم ان ليس نفكر ما هي السيناريوهات، ولكن يجب علينا السؤال المهم ان نفكر كفلسطينيين كيف يمكن لنا ان نساعد كريم خان وان نساعد طاقم المحكمه في اجراء التحقيق. باعتقادي بأن المرحلة الجاية المفترض أن على السلطة الفلسطينية وعلى دولة فلسطين بأن تعمل على ملاحقة جريمة الاستيطان وباقي الجرائم داخل المنظومة القضائية الفلسطينية، وهذا قد يساعد المدعي العام للمحكمة بأنه الجريمة مرتكبة داخل حدود دولة فلسطين أي على أراضي 67، وبالتالي قد لا ينعقد الاختصاص بحكم غياب السيطرة للسلطة الفلسطينية على هذه الأراضي، وبالتالي قد يتم نقل الاختصاص إلى المحكمة الجنائية الدولية وفق مبدأ التكاملي. هذا باختصار ما كنت أود الحديث فيه، وشكرا لكم وشكرا للضيوف الكرام.
شكرا شكرا أستاذ بشار على هذه المداخلة. ممكن Or should I switch on English maybe? Yeah, so thank you so much, Bashar, for this intervention. I think Hiba has a question also. We can move on to get Hiba's question and then return back to our guests for their opinion. Go ahead, Hiba.
Okay, thank you so much, Iman. Hi, everyone, and good evening. Thank you, Mr. Clancy and Professor Aisha for being with us today, for accepting our invitation and for your informative presentations. So my question here is clear forward. I was wondering, what are the possibilities of prosecuting crimes against humanity, such as apartheid, for example, taken in consideration that Bensouda just focused on war crimes in her decision to go ahead and initiate an investigation into the situation in Palestine? That was my question. Thank you. And I'm sorry for the my baby intervention. Thank you so much.
Thank you, Hiba. No worries. So we can have the opinions of Mr. Pearce or Dr. Aisha, and then we move on with another last round of questions. So I think Mr. Pearce wants to talk. Yeah, Mr. Pearce.
Oh yeah, thank you, Iman.
Yeah, you unmuted yourself. So do you have an answer or an opinion?
I do.
Yes,
and thank you, everyone, for your questions. I might address them in order if that makes sense. The first question on the possibility of Palestinians being brought before the court, I think, to be honest, that is, as if we get to the point where prosecutions take place, where trials take place, I think that is an inevitability. And I say that for two main reasons. The first reason is looking at the language, looking at the way that the Office of the Prosecutor has discussed the situation in the past. It seems very clear that what they want to do, and what they've wanted to do since Bensouda and before, since Ocampo, was to maintain the view of being balanced or being neutral. And you see that manifested in strange ways in different OTP documents, from the sort of annual updates, the way that they spend quite a bit of time sort of talking about the use of rockets by Hamas and other Palestinian armed groups, seemingly to offset the pressure or the criticism that they might get for, quote unquote, only focusing on Israeli perpetrators. But also, in particular, I'm thinking about the statement that Bensouda put out when she was opening her investigation. Because if you look at that statement, there is a strange paragraph where she talks about the Mavi Marmara flotilla situation, where she talks about how this is not a one-sided investigation into Israeli criminality. This is not a biased office that is conducting these investigations, because look, I closed and repeatedly made efforts to ensure that the Mavi Marmara situation was not progressed. And that is sort of held up as a concession, I guess, is how I read it, to critics of the court that talk about the court being prejudiced against Israel. My expectation is that if perpetrators are end up being brought to The Hague, that it'll be one for one. I would not at all be surprised if that's the strategy that's put forward by the OTP, that for every Israeli that you see in the dock, that we might see in the dock, you'll see a Palestinian. So it's one for one, right? That no one can point to the Office of the Prosecutor and say that they're engaged in anti-Semitic attacks or whatever the sort of delegitimization tactic might be at that point. I think that the Office of the Prosecutor is clearly very sensitive to that, and we don't know what lengths they might go to avoid doing that. The other reason I say that is because the ICC is an institution that is constantly in crisis, right? You constantly see observers talking about the ICC as the court needs a win here, right? The Office of the Prosecutor needs an easy case here to show that it is a legitimate institution, and this sort of discussions. And I think, at least my sense is, I don't know if this is true, but from people who are following the ICC and following the situation, I think they see the Hamas cases as quite easy to do. I think that they see, at least in the international sort of public opinion, the use of rockets by Hamas is an open shut case, and the ICC is always, quote unquote, looking for wins. And this might be something pretty easy to do for its lawyers to sort of bolster their legitimacy. So that's my immediate reaction on the question of Palestinians being brought to the Hague. I think it's an inevitability. Who they might be, I'm not sure. I think Hamas definitely for sure is an obvious bet. Potentially PA personnel, although I don't know. On the second question, which I think is interesting, on the potential use of Article 16 of the Rome Statute and the intervention by the Security Council, that has always sort of been a specter in the situation in Palestine and the situation in Afghanistan. In order for Article 16 to be triggered, the Security Council needs to act. And for the Security Council to act, you're going to need some serious political backing, probably in the form of multiple permanent 5 members. It's not impossible. It's never been done before. It's never been triggered. It's never been relied upon by the United States, by France, by the UK, or anyone like that. But it's possible. I think it's notable, though, that the US never even really attempted to do that, even when a criminal investigation was opened in the situation in Afghanistan. Not even Donald Trump tried to do that, right? Even though he imposed sanctions on Cuba and Zueiter and all of this kind of thing. And I think that, and I'm sort of speculating here, I think the internal logic behind that decision is that to engage with the court in that way would be, in a sense, to legitimize it. The American and the Israeli legal position is that the court doesn't have jurisdiction because essentially it cannot have jurisdiction over the personnel of non-state parties. That's sort of the generalist international law claim, despite the opposite being reflected in the Rome Statute, right? The Rome Statute literally says the opposite, but that's the claim. And I suppose that is the reason why there hasn't been direct engagement. Israel has been asked twice. It's been invited twice, off the top of my head, to my memory, to engage directly in the processes of the court. And it said no both times, because to do that would be to legitimize in its eyes what's happening there. I wonder if engaging in triggering Article 16 would be the same. On the point of access and how that works, it's very difficult to see how this investigation works, right? There's a lot of, and Bashar is correct, there's a lot of public information out there on settlements. So perhaps you can do that quite easily if you're an ICC investigator. Gaza, I think, is more, I'm still quite skeptical about Gaza. I'm quite pessimistic about whether or not Egypt will allow ICC personnel through its territory. First of all, because I don't think Egypt is terribly fond of the ICC. Anyway, that Egypt might be a little bit weary of getting too involved with the ICC. On one hand, and on the other hand, I'm recalling that Egypt refused to engage with, in particular, the 2018 Commission of Inquiry. It cited security concerns, sort of very vague security concerns, that it didn't want to engage with the Commission. And I'm concerned that Egypt may do the same in this case. And then the final question, very quickly, if I might address crimes against humanity. I think I would be surprised if the Office of the Prosecutor didn't look at crimes against humanity at all. It was a strange decision in the request for a jurisdictional ruling to only focus on war crimes, although I would note that the fact that Bensouda only referred to war crimes in that document does not preclude the investigation from being much wider. And Bensouda, while she was prosecutor, said that quite explicitly. Off the top of my head, on my memory, she said it in an exchange of views with MEPs, members of the European Parliament of the European Union, in a sort of a discussion, a public discussion that they had, that they hadn't made a determination at that early stage as to whether or not they will be looking at bringing crimes against humanity cases forward. I think it would be strategically quite silly if they didn't. Yes, settlements constitute the war crime of population transfer as found by the International Court of Justice and found to be in breach of Article 49.6 of the Fourth Geneva Convention by instruments such as or bodies such as the UN Security Council. But if you look at the Rome Statute, population transfer in that sense is not just a war crime, it's also a crime against humanity. So if you're prosecuting someone for being engaged in settlements or the construction and maintenance thereof as a war crime, I think you would be silly as a prosecutor not also to bring that charge under Article 7 on crimes against humanity. Whether the crime against humanity of apartheid is included, I think that's the question that everyone wants to know the answer to. That would be huge. I think that would be a massive victory, even if it was considered, even if an arrest warrant was issued. Whether or not the Office of the Prosecutor would go that far, unfortunately, the only person who can really say is Karim Khan. Even though we're obviously very supportive of the Office of the Prosecutor, I think it's important to remember that it's not a radical institution by any means, and may see charges of apartheid as very politically explosive, no matter how warranted I think they are, which I certainly do. But those are my reactions to those three questions, and thank you everyone for asking them.
Very, very interesting points that was brought up by Mr. Pearce. Thank you very much. I think Dr. Aisha, their connection was interrupted. Yeah. So until she is back, we can maybe take a round of questions. If anybody has a question, he can raise his hand or write the question in the chat. So we have one question in the chat from Hadil. It's kindly of a general question on how effective is actually the International Criminal Court in the case of protecting the rights of Palestinians and Palestinian and like actually serving the Palestinian case. Yeah, so this is the question about effectiveness of the court in the issue of Palestinian rights, like how can it bring back any rights for Palestinians? If we don't have any other questions, I can give the floor to Mr. Pearce to answer this question. Yes, yes, Mr. Pearce. Yeah, if you can say something on this.
Of course, and thank you for the question. I think the cynical answer is to say that in the direct aftermath of the pretrial chamber decision that the ICC was unable to protect, let's say, Palestinian victims in the Gaza Strip from Israeli bombardment, which speaks to, I think, the point that viewing the ICC in isolation and divorcing it from wider efforts at accountability and justice and emancipation will necessarily lead, I think, to disappointment. That the value of the ICC is to bolster wider efforts. And I think it has been leveraged to do that in quite subtle, maybe nuanced senses. So for example, through the litigation that took place in March 2020, where I believe 42 amicus curiae submissions and victims representation submissions were made to the court. That was really the first instance where Palestinian victims, through their lawyers, of course, had a chance to bring their grievances before an international court. That had never really been done before, and certainly not an international criminal tribunal or court. So in that sense, there's, I hope, some sense of a vindication there. Whether the ICC on its own can protect victims from further criminal conduct, from further criminal crimes, that depends on the wider machinery that's put in place and how the momentum that the ICC has contributed to is mobilized in pursuit of Palestinian emancipation and liberationism. So it's difficult to answer that question, I think, in isolation with regards to the ICC. I think the deeper question is, in the aftermath of what we saw in May, where do we go from here, and where does that momentum, particularly around the apartheid analysis and the language of apartheid, lead to? And for that, I think there is cause for optimism.
Thank you so much, Mr. Pearce. We'll come back, Dr. Aisha. We just had another question on the effectiveness of the ICC in actually protecting the rights of Palestinians. We have 2 minutes left. So if you have any concluding remarks or any additional points to answer the questions on whether crimes against the humanity such as apartheid can be brought before the court, or the question of the effectiveness actually of the court to bring back Palestinian rights. Yes, thank you, Dr. Aisha.
أريد فقط أن أوضح بأن يعني فتح التحقيق، عند فتح التحقيق كانت فاتو بنسودة جد واضحة، قالت بأن القضايا الجرائم المشتبه فيها التي سيتم التحقيق فيها إنما هي جرائم توضيحية illustrative only، بمعنى أنه حين سيفتح التحقيق، وهذا ما تم بالفعل، هناك إمكانية لإعادة طبعا توسيع نطاق التحقيق ليشمل قضايا أخرى وليشمل جرائم، يعني اختصاص جرائم أخرى. وهنا هناك إمكانية طبعا التحقيق في جرائم الأبارتايد. ربما هذا هو أكبر تحدي بالنسبة لكريم خان، لأن ذا لم يتم في محكمة أخرى يعني، لكن لكل أمر بداية، وهناك ما يكفي من الأمور الموثقة وأشخاص بعينها التي يعني معلومات ليس كأدلة. لا أعرف إذا كانت هناك أدلة بشأن أشخاص بعينهم يعني يسهل الأمر على المحكمة لإحضارهم أو طلب يعني مثولهم أمام المحكمة للاستجواب. لكن هذه الإمكانية غير يعني لا يمكن يعني إزاحتها، هي موجودة. لذلك أقول إنه إذا تم الضغط، يعني ما يكفي من الضغط على مستوى دولي وعلى مستوى أيضا فلسطيني يعني على كريم خان لكي يطلب يحقق في جرائم الأبارتايد، سيكون جد مهم ليس فقط يعني للمحكمة، وإنما لمشروع تقرير مصير ولمشروع التحرر النضالي للفلسطينيين اللي هو مشروع تحرر من نظام الأبارتايد. الآن هناك عديد من الأمور التي تمشي في هذا الاتجاه. يعني الناس المعنيين بالقضية المتابعين يظنون أن هناك فرص حقيقية لإعادة توصيف النظام الإسرائيلي بكونه أبارتايد، ولذلك يعني لابد من الضغط لإقناع كريم خان ليسير في هذا المجال، خاصة أنها جرائم ضد الإنسانية وتشمل عديد من الجرائم الأخرى التي رفعت للمحكمة لمكتب بنسودة. هذا من جهة. من جهة أخرى أظن أن كما قال الأستاذ بيرس بأن المحكمة يجب التوقف عندها، هي أداة من أدوات أخرى، أداة جد مهمة، لكنها طبعا المشكلة يعني بالنسبة لي أهم مشكلة في القضية في المحكمة أنها لا تحمل مسؤولية الجرائم للدولة، هي تحمل المسؤولية الجنائية للفرد، وتبقى الدولة يعني بعيدة عن هذه الجرائم، في حين أن الجرائم المنسوبة لإسرائيل هي جرائم دولة، هي جرائم مؤسسات، هي جرائم يعني لابد أن تخاض على هذا الشكل. وهذا هو النقص، يعني نقص كبير في الإطار العدالة الدولية التي تقدمها المحكمة الجنائية الدولية. لكن رغم كل شيء أظن أنه في فترة التحقيق هذه الجارية هناك طبعا إمكانية للاستفادة وللضغط وللتعريف أكثر على المستوى الدولي من ناحية الأدفوكسي، من ناحية كل الشركاء. وقد تكلمت في دراستي عن ضرورة إحضار يعني جهة structure لابد للفلسطينيين أن يتحركوا في إطار مؤسسي. واقترحت فكرة أنه شبكة أصدقاء إسرائيل لتضغط داخل المحكمة الجنائية وداخل منظمات الأمم المتحدة والاتحاد الأوروبي ومؤسسات المنظمات الدولية الكبرى، وأيضا تشبك مع المجتمع الدولي. فإذا كانت هذه المؤسسة موجودة ستسهل أكثر يعني جهود الضغط على كريم خان، لأنه كما رأينا فاتو بنسودة حين ابتدأت يعني العمل في المحكمة الجنائية الدولية كانت تسير في نفس المنحى لأوكامبو، كانت يعني تطبق السياسات ضد أفريقيا رغم أنها أفريقية، لكن حين كثر الضغط يعني عليها من ناحية الاتحاد الأفريقي ودول أخرى ومناصرين اضطرت لتغيير سياساتها وانفتحت على قضايا أخرى. وبالإمكان طبعا فعل نفس الشيء مع كريم خان، خاصة وهذه معلومة جدا هامة بالنسبة للفلسطينيين. كريم خان هناك نقطة جدا هامة في حياته، يقول أنه يشعر بأنه حفيد ظفر الله خان الذي كان رئيس محكمة العدل الدولية وكان رئيس الجمعية العامة، وكان شخصية جد مرموقة وأكبر المدافعين عن القضية الفلسطينية، وقد دافع عنها باسم الفلسطينيين عند قرار التقسيم ل 1947. وتربطه هو شخصيا تربطه علاقة صداقة يعني عائلية، ويقول أنه تأثر كثيرا بظفر الله خان. فهذا يعني أن القضية الفلسطينية بالنسبة له قضية هامة لمساره لقناعاته ولو أنه لا يتكلم عنها كثيرا، وقضية هامة أيضا لانتمائه للجماعة الأحمدية. فالضغط يعني أظن أن الضغط المناصرة جد هامة لتغيير مسار التحقيق يعني لدفعه يأخذ منحى إيجابي بالنسبة لمناسبة القضية الفلسطينية على العموم.
Thank you. Thank you very much, Dr. Aisha, for these very important points. So to conclude our session, so what we can say is that the success has already happened with the opening of the investigation and with the moving forward with the investigation, even though if the final results of arresting or Israeli officials might not be possible, and what we are relying on now is how the international community will be affected and how the image of Israel will be affected also by the opening actual investigation and the labeling of Israeli practices as criminal practices. I would like to thank you, our guest today, Dr. Aisha Al-Basri and Mr. Pearce Clancy. I also would like to thank all our participants in the room and also who are watching us on the YouTube channel. I would also like to thank finally our great interpreters, Noor Haki and Malik Derania. Thank you so much and have a nice evening. Bye-bye.